Before we dive into this story, let us know where you're watching from in the comments below. And if you believe homeowners should have rights, not be bullied by power-hungry neighbors, hit that like button and subscribe for more. This is a story about what happens when entitlement meets the law, specifically the law the homeowner herself helped shape, until she realized her HOA board saw her property as their personal kingdom to control. It wasn't the bustling cityscape or the manicured suburban lawns I was used to, but the quiet expanse of the countryside that had called to me after 3 decades on the bench. I'd spent years immersed in property law, in the intricacies of easements and covenants, presiding over disputes that hinged on a single misplaced boundary marker or the wording of an ancient deed. My decision to purchase the old farmhouse and its accompanying 50 acres wasn't merely retirement. It was a return to something fundamental, a connection to the land that city life had eroded. I wanted peace, privacy, and the simple satisfaction of watching crops grow and seasons turn. The property was just outside the boundary of a relatively new development, a sprawling collection of McMansions with an equally sprawling homeowners association. My farmhouse and land predated their existence by nearly a century, a fact I believed insulated me from their reach. I was wrong. My initial interactions with the preserve at Whispering Pines HOA were minimal. A friendly wave to neighbors walking the subdivision's loop, a brief exchange at the local general store. I received their unsolicited newsletters, which I politely ignored, assuming they understood my property was separate, beholden to county regulations, not their architectural review board. My land wasn't part of their plat map. It was the quiet, green space adjacent to their manicured borders. I maintained my fences, kept my property neat by country standards, which differs significantly from suburban HOA standards, thankfully, and minded my own business. I believed in being a good neighbor, which, to me, meant respecting boundaries, both physical and social. I assumed the HOA, comprised of my neighbors, would operate with a similar respect for boundaries. The first hint of trouble wasn't a direct confrontation, but a subtle creep. Surveyors appeared near the property line, little flags dotting the edge of my eastern field. They seemed focused on the HOA's side, laying out what looked like utility lines. I paid it little mind. Utility work happens. Then came the heavy machinery, digging trenches that skirted my boundary, still on their side, or so I thought. I saw board members, clipboard in hand, gesturing towards my fields. One afternoon, a woman I recognized from the HOA newsletter cover, a Ms. Carol Jenkins, their board president, stood at the edge of my property line, staring intently at the distant woods on my land. Her expression was less neighborly curiosity, more proprietary assessment. I was on my tractor, distant enough to feel observed rather than engaged. She turned and walked briskly back towards the development, still gesturing, still assessing. I felt a faint ripple of unease, but dismissed it as retiree on her land paranoia. Carol Jenkins was the kind of person who thrived on control. She had moved to the preserve at Whispering Pines with a clear mission: elevate property values through stringent enforcement and community beautification, as defined by her singular vision. She saw the HOA as her personal kingdom, the bylaws her decree. I'd heard snippets from other neighbors, complaints about nitpicky violations, excessive fines for minor infractions, and a general feeling that Carol and her small, loyal faction on the board ran roughshod over any dissent. They seemed particularly fixated on the subdivision's border, the liminal space between their ordered world and the wilder, older landscape of my farm. Carol spoke often in meetings, as reported in the newsletters I still received but didn't read thoroughly, about enhancing the natural buffer and community amenities. My quiet fields, it seemed, were the designated natural buffer. And the community amenities were about to become very personal. Then came the day the first foundation stakes appeared, not just near the property line, but unequivocally on my land. They were small, almost easily missed amongst the tall grass at the edge of the woods, but the bright orange ribbons tied to them were unmistakable. They marked the corners of several small structures. This wasn't utility work. This was construction layout. On my property. I walked the line, my heart pounding with a mix of disbelief and cold realization. The stakes extended deep into my woods, marking out not one, not two, but what looked like dozens of small structures, winding along a path I didn't know existed until I saw surveyors had cut a rough line through the underbrush. They were building something. On my land. Without asking. Without telling. The shock was profound, quickly followed by a surge of controlled fury. This wasn't a misplaced fence post or an encroaching shrub. This was a deliberate, large-scale trespass. They were building cabins, or some kind of structure, deep on my private property. My initial reaction was to grab the phone, call Carol Jenkins, and demand an explanation, demand they stop. But years of judicial temperament kicked in. Rushing and hot wasn't the strategic approach. I needed to understand what was happening, why they thought they could do this, and precisely what their legal basis, or lack thereof, was. I started meticulously documenting. Photographs of the stakes, close-ups of the ribbons, panoramic shots showing their placement relative to the known property line. I pulled out my old survey documents, confirming the boundary lines with the county records. My land was mine. Period. There was no question of ownership or boundary disputes on paper. I cross-referenced my deed against the HOA's recorded plat map. My property was clearly excluded. There was no easement granted to the HOA on my land. Not for utilities, not for access, certainly not for building. Then I started digging into the HOA's own documents, the covenants, conditions and restrictions, CC and RS. They had sent me, the meeting minutes posted on their website, the newsletters Carol so proudly curated. I searched for any mention of my property, any planned projects near the border, any easements. Nothing. The documents detailed rules about trash cans, lawn height, paint colors, but contained absolutely no claim or right to any land beyond the subdivision's recorded boundaries. How could they possibly justify building on my property? This level of entitlement, this blatant disregard for property rights, was staggering. The construction continued, oblivious to my discovery. Small crews arrived, clearing sections of the woods, pouring concrete footings. They worked quickly, efficiently, as if on a tight schedule. I watched from a distance, hidden by the trees on my side of the notional line they were ignoring. The sight of heavy machinery tearing into my quiet woods, the woods I'd bought for their peace and natural beauty, was a physical ache. They were building, not one or two, but what looked like cluster after cluster of small cabins, perhaps 20 in the section I could see, with more stakes indicating further expansion. They were building 100 cabins on my farmland. It seemed impossible, absurd, like something out of a fictional account of HOA madness. But it was happening. The HOA newsletters began to feature glowing updates about the new community nature retreat being built on the southern edge of the preserve. There was artist rendering showing charming little cabins nestled in the trees, connected by walking trails. Carol Jenkins was quoted extensively, praising the project's vision, its benefit to community values, its role in activating underutilized natural space. Underutilized? That was my private property, my quiet woods. Activating? They were destroying habitat and trespassing on an epic scale. The sheer audacity left me momentarily breathless. They weren't hiding it. They were promoting it as a community triumph. This wasn't a mistake about a boundary line. This was a full-blown, intentional land grab, based on what seemed to be a complete fabrication of their rights. My research deepened. I pulled up the state statutes regarding HOAs, property rights, and easements. I reviewed case law, focusing on trespass, adverse possession, which this clearly wasn't, as they weren't concealing their use, just their lack of right, and the limits of HOA authority. This wasn't just a review. This was revisiting the very laws I had applied, interpreted, and sometimes even helped clarify through precedent during my career. I knew these laws inside and out, and I knew, with absolute certainty, that the HOA had zero legal standing to do what they were doing. Zero. Their claim of underutilized natural space meant nothing. Their desire for a community nature retreat meant nothing. It was my land. I reached out to a trusted colleague, a retired judge specializing in property law, posing a hypothetical, an HOA building extensively on adjacent private land, claiming it's a community amenity, with no recorded easement. His reaction was immediate and strong. That's not hypothetical. That's criminal trespass and grounds for a major civil suit. Get a damn good lawyer and file for an immediate injunction. I smiled thinly. I was the damn good lawyer and judge, but I needed to do this by the book, ensuring every step was legally unimpeachable. I continued documenting the construction daily. Photos, video, timestamps. I noted the names on the construction trucks. I saved every HOA communication mentioning the nature retreat. I compiled a binder, thick with evidence, cold, hard facts of trespass and lack of justification. I also noted every time an HOA representative, usually Carol or another board member, came near the property line, observing the construction with proprietorial air. They looked satisfied, triumphant. They had no idea they were building their little kingdom on land owned by someone who knew the law better than they knew their own bylaws. One afternoon, Carol Jenkins herself came right up to the edge of my field where the woods began. She saw me watching from a distance. Instead of averting her gaze or offering a neighborly wave, she put her hands on her hips, a look of challenging ownership on her face, and pointed towards the construction deep in the woods. It was a clear gesture. This is ours now. Deal with it. That gesture, more than the construction itself, solidified my resolve. This wasn't ignorance, it was arrogant entitlement. They weren't operating under a mistaken belief. They were operating under the belief that they could simply take what they wanted and no one would stop them. They thought they had the power. I decided against confronting them directly. Sending a cease and desist letter from my personal stationery might tip them off, give them a chance to scramble, perhaps fabricate some excuse or claim ignorance. I wanted the full weight of the law to land on them when they least expected it, when they were deepest in their violation. My strategy became clear. Let them build. Let them sink their money, their time, their community's resources into their illegal project. The deeper they got, the harder they would fall, and the more irrefutable the evidence would be. I consulted formally with a law firm specializing in property litigation, but not as a potential client. I consulted as a fellow legal professional, seeking their insight on procedural specifics in this jurisdiction, confirming my understanding of recent case law developments since my retirement. I never revealed my identity as the landowner, only as someone with a complex property issue involving an HOA. Their advice mirrored my own conclusions: flagrant trespass, clear grounds for injunction and damages, potentially criminal charges depending on intent. They mentioned a specific case dealing with HOA overreach regarding common areas versus private property, a case I remembered well because I had written the majority opinion on the appeal. The irony was sharp, almost sweet. I was researching how to apply laws I had helped define against people who thought those laws didn't apply to them. The building continued through the late summer and into the fall. Structures took shape, simple wooden cabins, built on concrete slabs, connected by rough-cut trails. They were painting some of them, installing windows. The scope of the project was massive, covering several acres of my woods. The HOA newsletter showed photos of smiling board members standing in front of the half-finished cabins, talking about booking systems and community events. Their delusion was complete. They genuinely believed they were building this on their land, or land they had a right to use. I discovered the source of their delusion, or perhaps their willful ignorance, buried deep in old county planning documents. Years ago, when the preserve at Whispering Pines was initially approved, there was a proposal for a walking trail easement along the boundary line, perhaps 20 feet into what was now my property. It was just a proposal, contingent on negotiation with the then owner of the farmland. That negotiation never happened. The easement was never granted, never recorded, never finalized. It remained a rejected proposal in the planning archives. The HOA, or more likely, Carol Jenkins and her faction, had either deliberately misrepresented this old proposal as a valid, existing easement, or had somehow genuinely and negligently believed it was active. Even if it had been a valid easement, it would have been for a walking trail, maybe 20 feet wide, not 100 cabins covering acres. Their project went vastly beyond anything remotely discussed. This wasn't just claiming an easement. This was using a rejected proposal as justification for a full-scale invasion. This was the smoking gun on their intent or gross negligence. My preparation was complete. I had detailed photo and video evidence of the construction progress, clearly showing its location relative to my property markers. I had copies of my deed, the HOA's plat map, and the rejected easement proposal from the county archives. I had saved every HOA communication about the project. I had confirmed my legal standing and the relevant statutes and case law. I knew precisely which procedures they had violated, which laws they had broken. I drafted the complaint myself, meticulously citing the relevant statutes, attaching the overwhelming evidence. I wasn't just filing a lawsuit. I was laying out a legal argument that was, frankly, irrefutable. I decided to file not just for trespass and injunctive relief to stop construction and force removal, but also for significant damages, not just the cost of removing the cabins and restoring the land, but punitive damages for willful disregard of property rights. I also included a request for the removal of the current HOA board members for gross mismanagement and violation of fiduciary duties to the actual homeowners, whose dues money they were sinking into this illegal venture. This wasn't just about my land anymore. It was about holding them accountable for abusing their power and the community's trust. I filed the complaint electronically, ensuring service was made on the HOA's registered agent the following morning. I also sent a formal letter via certified mail to each individual HOA board member named in the complaint, informing them of the lawsuit and attaching a copy. The letter was brief, formal, and stated the facts. They had trespassed and built extensively on my private property without permission or legal right, and I was seeking legal remedy, including their removal from the board and damages. The reaction was exactly as I anticipated. Panic. The following day, I saw cars speeding in and out of the HOA president's house. Board members were huddled on porches, looking frantic. The construction crews, who had been working away just hours before, were gone, their vehicles conspicuously absent. They had clearly received the news. The sheer scale of their mistake, their illegal act, was dawning on them. Carol Jenkins herself came pounding on my front door that afternoon, her face pale, a crumpled copy of the lawsuit in her hand. She was no longer the confident, proprietorial queen of the preserve. She was scared. When I opened the door, she started talking immediately, a torrent of confused, panicked explanations. There must be a mistake. The easement. The plans. Community property. We thought. I held up a hand, stopping her mid-sentence. My voice was calm, steady, carrying the quiet authority of years on the bench. Ms. Jenkins, I received your newsletter about your community nature retreat. I saw the construction on my land. I have filed a complaint for trespass, injunctive relief, and damages. Service has been affected. Her eyes widened. Your land? But the easement. The 20 feet. And we've built so much. I stepped outside, walking slowly towards the edge of the field, motioning for her to follow. The stakes and footings were visible through the trees. That was a proposed easement, Ms. Jenkins, I said, my voice low but clear. A proposal that was never finalized, never granted, never recorded. It holds no legal weight. Even if it had been, it was for a walking trail, 20 feet wide, not for acres of cabins. What you have built is not on an easement. It is not on community property. It is on my private property. I paused, letting the weight of my words sink in. She was staring at the stakes, at the beginnings of the cabins, then back at me, her face a mask of disbelief. You see, Ms. Jenkins, I continued, looking not at her, but at the woods she had desecrated, I know a great deal about property law, about easements, about trespass. I spent 30 years working with these laws. In fact, I turned to face her directly, watching her eyes narrow in confusion. I was the judge who wrote the opinion in Patton versus Green Acres HOA. The case the law firm I consulted cited to you when you asked about HOA authority regarding adjacent property. The one that clarified HOA boundaries regarding non-members. I know precisely what your rights are, Ms. Jenkins. And more importantly, I know precisely what they are not. The color drained from her face completely. The realization hit her like a physical blow. The homeowner she had dismissed, the quiet retiree living outside her dominion, wasn't just a landowner. She was the legal authority who had literally shaped the laws she was now using against them. Her mouth opened and closed, but no sound came out. She understood. The power she thought she wielded was an illusion, and she had just used the community's money to build a monument to her own ignorance and entitlement on land owned by someone who held all the cards. The legal process moved swiftly. With the overwhelming evidence and the clear lack of any legal basis for their actions, the court quickly granted the injunction, halting all construction immediately. The lawsuit proceeded, and facing insurmountable evidence and the prospect of devastating punitive damages and legal fees, the HOA quickly settled. The terms were harsh. The HOA was required to pay for the immediate demolition and removal of all structures built on my property, pay for the complete restoration of the land to its original state, cover all my legal fees, and pay a significant sum in damages. Furthermore, the settlement stipulated the immediate resignation of Carol Jenkins and the other board members who had approved or facilitated the project. Carol Jenkins and her allies were removed from the board in disgrace. The community learned the full extent of their reckless mismanagement and illegal actions. The cabins were torn down, the concrete footings removed, and the long, slow process of healing the scarred earth began. I walked my woods again. The silence returned, albeit marked by the raw earth where the cabins had stood. The battle had been fought not with shouting or confrontation, but with patience, documentation, and a deep understanding of the law. My property was protected, my boundaries restored. And I had shown that true power isn't in bullying or false authority, but in knowing your rights and having the quiet strength to defend them.